Hey YouTube, Legal Doug here. Got another case here, another one. This is in the area of excessive force and deadly force by police officers. The case is Barnes v. Felix, and just to give you an idea who the parties are, it's Janice Hughes Barnes individually and as representative of the estate of Ashty and Barnes. And Ashty and Barnes is the person involved in the events underlying the case. He is deceased. He was unalived, I guess, by the police officer in this case, and who is the defendant, Roberto Felix. The case is it's in the Supreme Court. It was decided May 15th, 2025, so it's a recent case, and it comes out of the Fifth Circuit, which is pretty clearly one of the more conservative circuits in the United States right now. We'll skip over the attorneys. Let's take a look at the syllabus, just a summary. Syllabus is just prepared by the court. It's not formal or anything, but just to give you a summary of what's going on here. Respondent Roberto Felix Jr., a law enforcement officer, pulled over Ashty and Barnes for suspected toll violations. So not a major event right there, not a major violation right off the bat. Felix ordered Barnes to exit the vehicle, but Barnes began to drive away. As the car began to move forward, Felix jumped onto its door sill and fired 2 shots inside. Barnes was fatally hit, but managed to stop the car. About 5 seconds elapsed between when the car started moving and when it stopped. 2 seconds passed between the moment Felix stepped on the door sill and the moment he fired his first shot. Barnes' mother sued Felix on Barnes' behalf, alleging that Felix violated Barnes' Fourth Amendment right against excessive force. The district court granted summary judgment to Felix, applying the Fifth Circuit's moment of threat rule. The Court of Appeals affirmed, explaining that the moment of threat rule requires asking only whether an officer was in danger at the moment of the threat that resulted in his use of deadly force. Under the rule, events leading up to the shooting are not relevant. The case is all about that. Here, the precise moment of threat was the 2 seconds when Felix was clinging to a moving car. Because Felix could then have reasonably believed his life in danger, the panel held, the Fifth Circuit panel below of three justices held the shooting was lawful. And so held a claim that a law enforcement officer used excessive force during a stop on arrest is analyzed under the Fourth Amendment, which requires that the force deployed be objectively reasonable from the perspective of a reasonable officer at the scene. And that comes from Graham v. Connor. We just went over that case before. In fact, I intentionally did Graham v. Connor because I know it's a predecessor case for this issue. The inquiry into the reasonableness of police force requires analyzing the totality of the circumstances. That analysis demands careful attention to the facts and circumstances relating to the incident. Most notably here, the totality of the circumstances inquiry has no time limit, that 2 seconds that they were talking about between the time he stepped on the car door sill and when he fired. While the situation at the precise time of the shooting will often matter most, earlier facts and circumstances may bear on how a reasonable officer would have understood and responded to later ones. Prior events may show why a reasonable officer could perceive otherwise ambiguous conduct as threatening or instead as innocuous. And again, it goes both ways, and you'll see that. And then Plumhoff is a case that they're referring to here. They say it well illustrates this point. There, an officer's use of deadly force was justified at the moment, partly because of what had transpired in the preceding period. The moment of threat rule applied below prevents that sort of attention to context, and thus conflicts with this court's instruction, to analyze the totality of the circumstances, the rule that came out of Graham. By limiting their view to the 2 seconds before the shooting, the lower courts could not take into account anything preceding that final moment. So, for example, they could not consider the reasons for the stop or the earlier interactions. Again, toll violations were the reasons for the stop. Clearly not an indication of a violent situation here. So could not consider the reasons for the stop or the earlier interactions between the suspect and officer. And because of that limit, they could not address whether the final 2 seconds of the encounter would look different if set within a longer time frame. A rule like that, which precludes consideration of prior events at assessing a police shooting, is not reconcilable with the fact-dependent and context-sensitive approach this court has prescribed in Graham. A court deciding a use of force case cannot review the totality of the circumstances if it has put on chronological blinders. The court does not address a separate question about whether or how an officer's own creation of a dangerous situation factors into the reasonableness analysis. The courts below never confronted that issue, and it was not the basis of the petition for certiorari. And the opinion is delivered by Justice Kagan, and it's a unanimous court decision. So those are always ones that you really have to give serious consideration to. Justice Kavanaugh filed a concurring opinion in which Thomas, Alito, and Barrett joined. Obviously, the conservative side of the court there. Justice Roberts and Justice Gorsuch did not join in this concurring opinion. I'm not going to go over the background of the entire court here because it's a unanimous decision, and it's the existing court today that had put out this decision. So taking a look at Justice Kagan's opinion, a police officer's use of deadly force violates the Fourth Amendment when it is not objectively reasonable, again referencing Graham. And that inquiry into reasonableness, we have held, requires assessing the totality of the circumstances. The question here is whether that framework permits courts in evaluating a police shooting or other use of force to apply the so-called moment of threat rule used in the courts below. Under that rule, a court looks only to the circumstances existing at the precise time an officer perceived the threat, inducing him to shoot. Today, we reject that approach as improperly narrowing the requisite Fourth Amendment analysis. To assess whether an officer acted reasonably in using force, a court must consider all the relevant circumstances, including facts and events leading up to the climactic moment. So getting into the facts, on the afternoon of April 28, 2016, Roberto Felix Jr., a law enforcement officer patrolling a highway outside Houston, received a radio alert about an automobile on the road with outstanding toll violations. Felix soon spotted the car, a Toyota Corolla, and turned on his emergency lights to initiate a traffic stop. The driver, Ashton Barnes, pulled over to the highway shoulder. Parking his own car just behind, Felix walked to the Corolla's driver's side door and asked Barnes for his license and proof of insurance. Barnes replied that he did not have his license with him and that the car was a rental in his girlfriend's name. As he spoke, Barnes rummaged through some papers inside the car, causing Felix to tell him several times to stop digging around. Felix also commented that he smelled marijuana and asked if there was anything in the car he should know about. Barnes responded that he might have some identification in the trunk, so Felix told him to open the trunk from his seat. Barnes did so, while also turning off the ignition. All that happened, as a dash cam recording of the incident shows, in less than 2 minutes. Then things began moving even faster. With his right hand resting on his holster, Felix told Barnes to get out of the car. Pennsylvania v. Mims, he has the right to do that. Barnes opened the door, but did not exit. Instead, he turned the ignition back on. Felix unholstered his gun, and as the car began to move forward, jumped onto its door sill. He twice shouted, "Don't effing move," and with no visibility into the car, because his head was above the roof, he fired 2 quick shots inside. Barnes was hit, but managed to stop the car. Felix then radioed for backup. By the time it arrived, Barnes was dead. All told, about 5 seconds elapsed between when the car started moving and when it stopped. And within that period, 2 seconds passed between the moment Felix stepped on the door sill and the moment he fired his shot. Barnes' mother, Janice Barnes, sued Felix on her son's behalf. The suit, brought under 42 U.S.C. 1983, we've seen that in almost every case, it seems, alleged that Felix had violated Ashton Barnes' Fourth Amendment rights by using excessive force against him. The district court granted summary judgment to Felix, so the police officer was deemed to have acted reasonably. The court explained that to prevail on her claim, Mrs. Barnes needed to show that Felix's use of force was objectively unreasonable. In the usual excessive force case, the court noted the inquiry into reasonableness would involve considering a variety of circumstances. But when an officer has used deadly force, the court continued, the Fifth Circuit has developed a much narrower approach. And that's kind of, the core of what this case is about. Then a court could ask only about the situation existing at the moment of the threat that sparked the fatal shooting. The district court identified that moment as the 2 seconds before Felix fired his first shot when he was standing on the doorsill of a moving vehicle. At that moment, the court found an officer could reasonably think himself at risk of serious harm, and under the Fifth Circuit's rule, that fact alone concluded the analysis. The court explained that it could not consider what had transpired up until those last 2 seconds, including Felix's decision to jump onto the sill. Although a more robust examination might have aided in assessing the reasonableness of the shooting, the court was duty-bound by circuit precedent to limit its focus to the exact moment Felix was hanging onto Barnes's moving car. The Court of Appeals affirmed, so the district court had decided that based on Fifth Circuit precedent, and the Fifth Circuit now is coming in after them and affirming. So the Court of Appeals affirmed, explained that it too was bound by this circuit's moment of threat doctrine. Under that rule, the panel agreed the inquiry is confined to whether the officer was in danger at the moment of the threat that resulted in his use of deadly force. Again, a 3-judge panel is usually what you see in these circuit court decisions, one level below the U.S. Supreme Court. Any prior events leading up to the shooting, including actions the officer took, were simply not relevant. And here, as the district court found, the precise moment of the threat was the 2 seconds when Felix was clinging to a moving car. Because Felix could then have reasonably believed his life in danger, the panel concluded his decision to shoot did not violate Barnes's constitutional rights. In a concurring opinion, Judge Higginbotham, a long-standing Fifth Circuit well-known justice, who also authored the panel opinion, expressed concern with the Fifth Circuit's moment of threat doctrine. So he doesn't like the doctrine itself. He thought that rule inconsistent with this court's directive to assess the reasonableness of an officer's use of force, including deadly force, by looking to the totality of the circumstances. Under the totality approach, Judge Higginbotham wrote, a court could consider not just the precise millisecond when an officer deploys force, but everything that had transpired up until that time. And with that wider focus, Judge Higginbotham would have found that Felix's shooting of Barnes was unreasonable. We granted certiorari to address whether, in resolving Fourth Circuit excessive force claims, courts may apply the moment of threat rule just described. We hold they may not, because that rule constricts the proper inquiry into the totality of the circumstances. So there you go. You have to consider all of the circumstances leading up to the shooting. So part 2, a claim that a law enforcement officer uses excessive force during a stop or arrest is analyzed under the Fourth Amendment. The touchstone of the Fourth Amendment is reasonableness, as measured in objective terms. So the question in a case like this one, as this court has often held, is whether the force deployed was justified from the perspective of a reasonable officer on the scene, taking due account of both the individual interest and the governmental interests at stake. That inquiry into the reasonableness of police force requires analyzing the totality of the circumstances. There is no easy-to-apply legal test or on-off switch in this context. Rather, the Fourth Amendment requires, as we once put it, that a court slosh its way through a fact-bound morass. Or said more prosaically, deciding whether a use of force was objectively reasonable demands careful attention to the facts and circumstances relating to the incident as then known to the officer. For example, the severity of the crime, toll violations in this case, prompting the stop, can carry weight in the analysis. So too can actions the officer took during the stop, such as giving warnings or otherwise trying to control the encounter. And the stopped person's conduct is always relevant because it indicates the nature and level of the threat he poses, either to the officer or to others. Most notably here, the totality of the circumstances inquiry into a use of force has no time limit. Of course, the situation at the precise time of the shooting will often be what matters most. It is, after all, the officer's choice in that moment that is under review. But earlier facts and circumstances may bear on how a reasonable officer would have understood and responded to later ones. Or as the federal government puts the point, those later in-the-moment facts cannot be hermetically sealed off from the context in which they arose. Taking account of that context may benefit either party in an excessive force case. So those earlier facts could make the action reasonable, or they could make the action unreasonable, but you have to consider them. Prior events may show, for example, why a reasonable officer would have perceived otherwise ambiguous conduct of a suspect as threatening, or instead, they may show why such an officer would have perceived the same conduct as innocuous. The history of the interaction, as well as other past circumstances known to the officer, thus may inform the reasonableness of the use of force. The court's decision in Plenhoff well illustrates the point, and then it goes through a whole description of a case where the prior escape attempt by the perp and other activities gave some context to what happened afterwards. You could read that if you like. But we'll skip over that. The moment of threat of rule applied in the courts below prevents that sort of attention to context, and thus conflicts with this court's instruction to analyze the totality of the circumstances. Recall that the District Court and Fifth Circuit limited their review to the 2 seconds before the shooting, after Felix has stepped onto the door sill of Barnes's car. Those courts believe that under Fifth Circuit precedent, they cannot take into account anything preceding that final moment. And then goes on to say, so, for example, they could not consider the reasons for the stop or the earlier conduct of and interactions between the suspect and officer. And because of that limit, they could not address whether the final 2 seconds of the encounter would look different if set within a longer time frame. It is as though the court in Plenhoff could consider only the instant when the chased car was at a near standstill, and not the earlier time when it zigzagged down a busy roadway at speed. To be sure, historical facts will not often matter as much as they did there to the reasonableness analysis, and some of those facts may not be relevant at all, but no rule that precludes the consideration of prior events in assessing a police shooting is reconcilable with the fact-dependent and context-sensitive approach we have prescribed. The court deciding a use of force case cannot review the totality of the circumstances if it has put on chronological blinders. That point is so evident that not even Felix, you know what, we're going to skip over this part. It's just a reference to some arguments made or not made. You can read that if you like. But whatever might be said of Fifth Circuit law generally, the decisions below applying a rule about timing, as shown above, both lower courts took pains to explain that in evaluating the shooting's reasonableness, they could look only to a 2-second snippet of the encounter. And because that was the reasoning in the case before us, that is the reasoning we must address. It can make no difference to our decision here if the Fifth Circuit in other cases eschewed a strict time limit, as Felix claims. Again, that was the argument that he was making up above. So we'll skip down here. And this circuit, however, has narrowed that test in deadly force cases, holding that the inquiry there is confined to whether the officer was in danger at the moment of the threat that resulted in the officer's shooting. The problem with this statement is apparent. As we have explained, a court cannot thus narrow the totality of the circumstances inquiry to focus on only a single moment. It must look to, in this and all excessive force cases, at any relevant events coming before. We do not address here the different question Felix raises about the use of force cases, whether or how an officer's own creation of dangerous situation factors into the reasonableness analysis. That's a different issue, not in before the court here today. With that matter resolved, we return everything else to the courts below. It is for them now to consider the reasonableness of the shooting using the lengthier time frame we have prescribed. So they're not saying the judgment should go the other way. They're just saying we're going to send it back and have it analyzed under the proper analysis as the Supreme Court has set it out. Accordingly, we vacate the judgment of the Court of Appeals and remand the case for further proceedings consistent with this opinion. So that's the opinion. They're just saying you can't just look at those 2 seconds. I mean, you've got to look at all of the other factors leading up to what that point in time. But they're saying they're not going to address if the police officer made some mistake that put him in that situation where he had to defend himself in some way, that's a different issue. But they're just saying that you can't just look at those 2 seconds. You have to look at the facts and circumstances leading up to it. So then Justice Kavanaugh writes a concurring opinion joined by the 3 of the other conservative justices on the court. Again, Gorsuch and Roberts, I don't think align that closely on a lot of things, other than both are considered more conservative. So I'm not sure why one or both of those are not joining in this concurrence, which would have then made it part of the opinion. So Justice Kavanaugh says, I join the court's opinion. I agree that the officer's actions during the traffic stop in this case should be assessed based on the totality of the circumstances. So the whole point of the case, he and the other concurring justices are in agreement. He says, I write separately to add a few points about the dangers of traffic stops for police officers, particularly when, as here, the driver pulls away in the midst of a stop. And so we're not going to go through all of this. It's not relevant to the point of the case. He's just saying that there's a particular danger involved when someone that you pulled over actually tries to then get away. And he goes through a list of 3 or 4 different scenarios why that's dangerous. Either you chase them and have a dangerous chase in public, or you don't chase them and you've let somebody get away that you actually had at that time. But he goes through those different scenarios, and he talks quite a bit about why police officers, how this is such a dangerous situation for the police officers themselves. And so that's the general point of the concurring opinion. And I think it's to give guidance to courts in the future, when they're assessing specific facts and circumstances. He wants these considerations to be made. So, and he finishes off by saying, I could go on. The point here is that when a driver abruptly pulls away during a traffic stop, an officer has no particularly good or safe options of those 3 or 4 or 5 scenarios. None of the options available to the officer avoids danger to the community, and all of them require life or death decisions that must be made in a few seconds in highly stressful and unpredictable circumstances. Of course, when an officer uses force against a fleeing driver, the judiciary still must assess any resulting Fourth Amendment claim under the standard of objective reasonableness. Under this court's precedents, that inquiry involves a careful balancing of the nature and quality of the intrusion on the individual's Fourth Amendment interest against the countervailing governmental interests at stake. So in conducting that analysis, judges should keep in mind that it is one thing to dissect and scrutinize an officer's actions with a 20/20 vision of hindsight in the peace of a judge's chambers. It is quite another to make split-second judgments on the ground in circumstances that are tense, uncertain, and rapidly evolving. So it seems to be wanting to influence courts on how they do, in fact, do this analysis. In analyzing the reasonableness of an officer's conduct at a traffic stop, particularly traffic stops where the driver has suddenly pulled away, courts must appreciate the extraordinary dangers and risks facing police officers and the community at large. So that's his point. It's just these are dangerous times where police officers often have to make split-second decisions. As always, I always suggest go ahead and read the notes to the case. This one has very few. There's only 4 notes that are right there. But they always do add some additional context to the decision and some other background information. So that is the case. That's a very recent case. I see that one mentioned quite a bit in the legal arenas. So I wanted to go ahead and address that. If this has been interesting at all to you or helpful at all, I'd appreciate a like. And if you have a comment on the case, I absolutely would be happy to engage in the comment section. And if you have any interest in being notified when I've got other cases analyzed, the point of this channel is just to really let you see the words of the court themselves and not be just relying on how some legal expert is describing the opinion. I think it's helpful. I think that most people can understand what the court is saying in most cases. And I think it's helpful to see the actual opinion itself. So anyway, that's the point of the channel. So again, if that sounds interesting to you at all, would absolutely appreciate a like and a subscribe. And we will have another case here shortly. Thank you very much for your time.